Right, welcome back. You'll notice that I got some new markers which should significantly improve my handwriting. At least they were more expensive. So hopefully my handwriting will get better going forward. So chapter 4, we are looking at jurisdiction, which you've all been waiting for. Most of the issues there are things that we've discussed already because we talked about in the previous chapter, right, previous two capsules last week. We talked about rule-making power and decision-making power, both of which we said can be delegated to an administrative decision-maker. And these are different, right? First one we looked at was decision-making power. We said that that is delegated by the legislature, which has the control over that by virtue of the Constitution, has the power to delegate that to an administrative decision maker, right, by virtue of something like a statute. And that power comes from the court. That's where the distinction lies, right? So that power is removed from the inherent jurisdiction of the superior court, which I won't bore you with again, right? But by default, it's with the superior court. Legislature has the prerogative to remove that from the superior court, give it to someone or something else. So legislature does the delegating, the superior court gets the power removed. Rulemaking power is different in that the legislature is doing both. So the legislature is delegating power to make rules that it otherwise has. So the legislature does the delegating, again by virtue of something like a statute, and then delegates it to an administrative decision maker who subsequently exercises it in the place of the legislature, which has the power to make the rules in the first place by virtue of the Constitution. So you'll recall that that has involved many of the issues of jurisdiction that we're looking at in this chapter, because the first rule is that, right, there is no inherent jurisdiction of an administrative decision maker. That was quoted from the previous chapter. What's that mean? It means that the administrative decision maker only has the power that are specifically delegated to it by virtue of the statute or whatever it is. Doesn't have other powers naturally. So you have to look to the statute. If you can't find it, it doesn't exist, right? It can be implied in the statute, but if it's not there, it doesn't exist, right? There's no magical power. Unlike the legislature, which by virtue of the Constitution has a lot of power, right? Everything generally in Canada in terms of legislative power is either with the federal government or the provincial government. So when you combine the two, you've got everything there, right? Administrative decision makers don't work that way. They only have what is specifically delegated to them. And therefore, right, the issues of rulemaking power or decision-making power are issues of jurisdiction within the meaning of this chapter, which we looked at, because you have to evaluate every time the scope of that power, and that is a jurisdictional issue. That's what no inherent power means. You'll recall that there are two exercises happening there, both of which are important. I mentioned that in the live portion for last week. So first you have the government, right, which has the power in the first place, whatever it is, by virtue of the Constitution. As we said, right, the Constitution's God, that's where the government gets the power in the first place, right? The government has to have that power in the first place, right? So you look at, sorry, this is incorrect there. So the Constitution, right, is going to give the government a certain power, which it has to have in the first place. And then eventually that will get delegated to an administrative decision maker. So government gets it from the Constitution. The Constitution's God, right? It has to come from somewhere, and that is the Constitution. So for this whole thing to happen, which is what we see in administrative law, you've got to have in the first place the power come from somewhere, that is the Constitution. So the Constitution has to grant the government that power, and generally that's an issue of jurisdiction because by virtue of 91 and 92 of the Constitution, some things are with the federal government, some things are with the provincial governments, right? So that's jurisdiction. Some stuff is with one, some stuff is with the other. You have to determine whether the stuff is with the correct government that's trying to exercise it, right? That's an issue of jurisdiction. Then the government is going to grant that power to an administrative decision maker by statute or something else, right? Then the administrative decision maker who's making a decision or doing something that you're reviewing upon judicial review. So passing a rule by virtue of rule-making power, regulation, or making a decision by virtue of decision-making power. It's doing something there, which it has to have the power to do, and that comes from the statute that delegates that power from the government or from the courts by the legislature, right? Both cases by the legislature. So two jurisdictional issues there. First, the administrative decision maker, and that's what we'll focus on for this chapter, has to have the power that it's exercising. And to see that, you look at the instrument which creates that power, and that is the statute, generally, which delegates the power from the government to the administrative decision maker. However, when you go upstream, to be able to delegate that power, the government has to have it, and that's by virtue of the Constitution. So if the federal government is, for example, delegating a power that is within provincial jurisdiction, that's not allowed, right? So it's delegating a power it doesn't have, which makes the whole thing invalid because it doesn't have that power here, therefore can't delegate it to someone else, right? It doesn't have it in the first place. And so you've got two jurisdictional issues there, the arrows, both of which can eventually invalidate the administrative decision because you're just going upstream and looking at where the power comes from in the first place. Okay, then you have the standard of review, which I kind of lied to you about so far to simplify things. Per Vavilov, which again is the precedent that you should read in your free time, which has redefined the entire framework in Canada in 2019. Very late December, I think, 2019, right? It was getting confusing because the framework for judicial review of administrative decisions is not clear. It's not laid out by statute, right? It's just the courts making it up as they go. When they do that, it turns out to be bad, and so, right, 10 years later, they've got to do the thing over. That's what they did. So they, renovated something called Dunsmuir in the Vavilov case and redefined the standard that applies. Vavilov in general, again, you should read it in your free time. Vavilov in general says that there is a presumption of reasonableness review. Sorry, it's the COVID vaccine. So prior to that, you had, again, two standards of review, correctness, reasonableness, right? You had to determine which one you fell under. Under Vavilov, it is simpler in that there is a default standard, and that's reasonableness. So if you're not sure, it's reasonableness. There's a default presumption, and therefore one is likelier than the other in that if you don't know, it's reasonableness. That's what presumption means, right? And so by implication, unless it is one of the things that is specifically correctness, it is reasonableness. That presumption applies to jurisdictional issues, kind of. That's what the court says, but as we'll see, it's actually more complicated than that. But by default, it is reasonableness. The reality is, sometimes it will be correctness, And when it's a real jurisdictional issue, it kind of is correctness, even though the court said otherwise. The reason the court said that is because most jurisdictional issues, if you count them in the cases, are going to be issues that are not really about jurisdiction and that are not really clear. So if you have a decision maker just doing something it has no power to do, you've got a guy, right, issuing a license, the guy just doesn't have the power to issue licenses. That is a jurisdictional issue in the simple sense of the term, in that he is exercising a power he doesn't have. Then it's clear. And then it would be subject to correctness review because it's simple. There's a single possible answer. There's no statutory interpretation. There's no uncertainty. He's just doing something completely illegal. Just as if the federal government is exercising a power that's clearly within provincial jurisdiction. That, pursuant to Dunsmuir, which was a precedent before Vavilov, was what the court called a true jurisdictional issue. Then in Vavilov, the court eliminated that category because it became unclear and because the parties were pleading it all of the time. And the court didn't like that. So it said by default it's reasonableness. But really, if you establish the same thing, which is what I just mentioned, a simple jurisdictional issue where the decision maker is simply doing something they just don't have the power to do, it is still subject to correctness review. It's just harder to show because you have to rebut the presumption of reasonableness, as opposed to simply show a true jurisdictional issue, which again does not exist now as a separate category. The thing about that is, most of the time that's not the problem. Most of the time it's not clear. Most of the time you'll have a statute that can be interpreted many ways, and therefore it makes sense for reasonableness to apply. It's just not clear. The government's going to say you've got power to award compensation. Does compensation include punitive damages? Does compensation include medical costs? Does compensation include legal costs if you're behaving badly in court? There's no simple answer. This is not the guy issuing a license when he doesn't have a right to do that. It's an exercise of statutory interpretation, namely the meaning of damages or costs, whatever the statute says. And there is no clear answer. And it makes sense for reasonableness to apply. In fact, that's what reasonableness is. Reasonableness is a recognition that in administrative decision making, there are often more than one possible solutions, and therefore you want to show deference to the administrative decision maker because it's more efficient and they have more expertise. That is subject to reasonableness review, and that happens a lot more than the simple issue of the guy issuing a license he doesn't have the power to exercise. And that's why the court wanted to create that presumption. Because the way things actually turned out in court, as things went forward, the parties would say, well, jurisdiction is an exception, it's correctness reviews, which if you're trying to get a decision quashed, you want correctness review. It's less deferential. You're more likely to get the court to intervene. If you lost and you're trying to have it reviewed, that's what you want, And that defeats everything we saw so far, because the court redoes the exercise, that adds costs, delays, You don't have the expertise of the decision maker. Court didn't like that, especially given that most issues of jurisdiction were things that were subjective to start with, and therefore did not lend themselves naturally to that correctness review standard. On top of that, usually the power is even less clear to start with. It's not even as clear as what I said where you have, the power to issue costs or damages. The government is going to give a very broad grant of jurisdiction. So it's either going to say, again, court tribunal, gets to make up the rules. Or it's going to say, has all the powers necessary to exercise jurisdiction over cars in Canada. So then it's not even a matter of statutory interpretation in interpreting the meaning of a word. It's interpreting the meaning of a power. And that you see a lot of in administrative law, which is a very unique feature of it, which makes it even more subjective and even more likely that an issue of jurisdiction is going to be subjective, unclear, is going to require interpretation, and is going to be subject to a number of possible outcomes and therefore lend itself to reasonableness review. That doesn't change the fact that if you have a real jurisdictional question, the guy issues a license with a power he doesn't have, or the guy exercises a power of the provincial government that was delegated to it by the federal government, that is clear and is going to be subject to correctness review. But that is very rarely going to be the issue. It's going to be more complex and subjective, and that's why the court, right, wanted to avoid the parties being able to claim that everything was a jurisdictional issue when in fact the vast majority weren't in that sense, and therefore, right, were appropriately subject to reasonableness review. And that's mentioned throughout the chapter, right? Page 171 at the top, you've got a distinction between two kinds of issues. That's essentially what I've just explained. In all of these cases, right, this remains, and this is something I emphasized in class last week, this remains a preliminary issue in the sense that you're not looking at the substance of the decision. So, say the guy has the power to issue a license. Then that decision can be reviewed on its substance. So he does not issue a license. You can say that denial of a license, that's an administrative decision, is not reasonable or incorrect, right? Because it does not apply the statutory criteria. So statutory criteria say you've got to look at whether the guy's blind. You don't look at whether the guy is blind. Or you do look at it, but you make an unreasonable interpretation of the record because the guy isn't actually blind, right? In reality, it would probably be something more subjective, like the guy is a danger to public safety, right? Then it's a matter of either whether you don't look at it at all when you have to by virtue of the statute, or whether you look at it unreasonably. So you look at the facts and you come to a conclusion that just doesn't make sense, right, from the facts. It's the substance of the decision. Jurisdiction is different in that it's kind of a preliminary issue. You're not looking at the substance of the decision. You're looking at whether the person has the power to make that decision in the first place. And as I emphasized in class, right, these are things that you always want to look at as preliminary issues, the constitutional context, the jurisdiction, right, before you assume that the person had the power to make that decision, and therefore that you can apply the standard of review to it, as we'll see for the rest of the term, and determine whether or not it is reasonable or correct. Okay, the jurisdiction, of course, can be implied, and that just makes sense, right? So first, right, a tribunal or a decision maker will need to have the power necessary to exercise its powers. So if it says that, right, car tribunal makes decisions on cars, then by implication, it has to have the sufficient jurisdiction, which means determining damages, determining personal injury, whatever it is that's necessary to exercise that. So of course you don't need, right, the government to specifically say the car tribunal has the power to give people money. That will come by implication. Nonetheless, it has to be clear. It will be clear that, right, if it needs to have the requisite power, that will involve, right? Giving people money because that's how you adjudicate claims regarding car accidents, for example. That's implied in the sense that it's not specifically mentioned, but it still has to be mentioned in some way. You can't just make it up, right? It has to be clear that the tribunal has a certain power, namely to adjudicate claims on cars, and then you can assume that it has the requisite sub-powers to exercise that. But you can't assume right beyond that, because then you'd be going beyond the statute and attributing a jurisdiction, right? Jurisdiction that doesn't, that's not established by the statute. Okay, then page 176, you've got an important passage from Vavilov, which again, you should be reading in your free time, which is helpful for our purposes. It's going to be helpful going forward as well. So I want you to read it there, right? Second last paragraph, page 176. This is true of interpreting a statute. It's true generally as well. So where the interpretive exercise conducted by the administrative decision maker is set out in written reasons, as we'll see, that varies. Sometimes the administrative decision maker will write up something that explains why they made a decision, kind of like a court. Court issues a judgment, that's a written something that explains to you why they did what they did. And then that helps you show that they're wrong if they are on appeal, right? Then you go to court of appeal, you say, right, look at this piece of paper. This piece of paper makes no sense based on what we showed them, therefore we want it reversed. Sometimes the administrative decision maker will do that. That's called the reasons for the decision. Sometimes it will be a 20-page document that explains it. Oftentimes it won't be, because administrative decision makers are supposed to do things faster, right? So immigration officers at the embassy, they are administrative decision maker. They deny visas all the time. They won't write up a 20-page document every time. They'll have notes in the system that will explain it, and that will be sufficient. Sometimes 2 paragraphs will be sufficient, and sometimes you'll be allowed to make up from the record, right, the rest of the explanation for it, which in the end has to make sense under the standard of review, but doesn't have to appear on the face of the record. So all that to say, the reasons for the decision will vary. If you're denied a license, for example, right? It's not clear what the reasons are. The reasons will vary in length, in type, might not be written, but as the court says there, might be and often will be substantially different from what you have in a court. And that's true all of the time. So it's true for statutory interpretation. So you might not have, right, a 10-page document that explains why the tribunal decided it had jurisdiction to award money. Nonetheless, that doesn't mean that that decision is not valid, right? Because it is the nature of an administrative decision that it might substantially differ from what a court would have done. So when it is set out in written reasons, it may look quite different from that of a court. Going forward, the specialized expertise and experience of administrative decision makers may lead them to do that. On top of that, may lead them to rely, in interpreting a provision, on considerations that a court would not have thought to employ, but that actually enrich and elevate the interpretive exercise. If you think that's scary, I thought it was scary at first, and second glance. This means that they can do everything differently. And that's why you're giving that power to an administrative decision maker, who again often won't even be a lawyer. And so they won't necessarily reflect in lawyer-like ways, and even in legal terms. So they might cite stuff that seems extremely weird to a court. They might cite it in a way, right, in an interpretive exercise that is very weird. And that still counts because you want them to be able to make that decision in a way that ostensibly calls upon their specialized expertise. It's one of the reasons why you have reasonableness, right? Because, again, they'll do things very differently. The court won't necessarily have done it the same way, but you want them to do that, and that's the flexibility that we have in administrative law. And the court even says, right, that enriches the decision making of administrative decision makers. Similar thing that's mentioned in 177 in the context of interpretation, still true beyond that, are not required to explicitly address all possible shades of meaning. So they don't have to explain the 5 interpretations that they reject to justify the one that they don't. And that's true generally, because again, they don't have to do a 20-page document where they cite every piece of evidence and explain why it's not applicable. The nature of their decision, the length of it as well, can substantially differ from what you'd see in a court. That's cited there on jurisdiction, but it's true generally of the nature of administrative decisions on everything. So we'll see them on the substance, on jurisdiction, right? But that's true on charter grounds, which we discussed, right? That's true on all of administrative decisions on all issues, right? That's their form in how they're built and written. Okay, so no true jurisdictional question, at least per the Supreme Court. Default standard is reasonableness. Nonetheless, if it's a simple, actual jurisdictional issue that lends itself to a single answer, it will be subject to correctness review, because correctness review implies a single answer. So for example, if the decision maker is exercising a power that they clearly don't have, either expressly or impliedly. The nature of the remedy will vary accordingly, and that just makes sense. If it's reasonableness review, there are more than one possible interpretations. Therefore, the court will generally be reluctant to substitute its own decision for the decision of the administrative decision makers. We said that multiple times already. Notably because it adds cost delays and all that, right? Even when it's unreasonable. So the court says what they did is clearly wrong. It's not reasonable. There's 5 possible decisions on this. This is not one of them. Nonetheless, the court will then have to do something. There's a remedy for that. But the remedy won't be the court substituting its own decision for that of the administrative decision maker. It will be quashing it, as we said, which is the default remedy, so canceling it and sending it back for redetermination by another decision maker who will then have to make a reasonable decision. Obviously, the implication from this is that they can't make the same one, right? Because the same one was just found unreasonable. And there's various permutations of that, right? So sometimes the court will send instructions, sometimes the court will send, right, coercive instructions to make sure that, right, the bureaucrats don't just ignore their obligation to decide. But 99% of the time it will be some permutation of sending it back, right, with or without more or less extensive instructions, but sending it back for redetermination by an administrative decision maker. Correctness review does not lend itself to that, because correctness review, as we just said, implies that there's a single possible answer. So if you're saying it's incorrect, the guy said he had the power, he didn't, then it doesn't lend itself to sending it back. You can still send it back, of course, right, for redetermination, but in the redetermination there won't be any discretion, any reasonable outcomes, because you just said that's what correctness review is, right? There's no deference, there's a single possible interpretation, and you didn't get it. So even if as a court you don't say this is the correct interpretation, you're saying it impliedly by saying there's a single one, this is not it. And then when you're sending it back, right, even when you're sending it back, in actuality, you know how the subsequent decision maker will decide. And therefore, sometimes the court will simply substitute its own decision for that of the administrative decision maker, because it's essentially useless to send it back. But the presumption remains, right, that the default remedy in administrative law is, regardless of why you're quashing it, to quash it and send it back. Okay. Then you have the exceptions there, 183. It's mentioned that, again, we get back to things we mentioned earlier with statutory rights of appeal. The government can show its intention to have a more or less deferential standard of review. The court's going to respect that. When there's a right of appeal, that suggests that the government wants the decisions to be reviewed. And therefore, it's less likely that reasonableness review will apply. You have them at footnote 71, which I'm sure you read. And that's from the Vavilov case. You've got an exhaustive list there, footnote 71, page 186, of the exceptions that were laid out by the Supreme Court in Vavilov. So the remaining ones where correctness review applies. Otherwise, as we said, if it's not that, there's default presumption that it is reasonableness review which applies. And these are, first, where the statute prescribes a different standard. Again, obvious intention of the government. Second, where the statute provides an appeal with or without leave being permission. So, example, right, you don't have a right to go to the Supreme Court unless it's a weird criminal case. You have to ask for permission. Same thing in administrative law. Even if you have to ask for permission, it suggests that the government wants it reviewed. Therefore, correctness review will apply. 3, constitutional questions. Everything we said so far. Right? You don't want some bureaucrat who's not a lawyer to make decisions on either very important things having to do with the Constitution or constitutional rights. And you don't want these decisions, right, once they're made to have a broader impact on future cases. 4, general question of law of central importance to the legal system as a whole. As we said, that's the one people use to camouflage whatever they want, right? There's very few of them, and the ones that are, right, that's a broader category, so everyone tries to use it. But there's very few of them. The ones that are usually will be things similar to constitutional issues, right? So things where you'd have an impact on lots of other cases because you're invalidating or interpreting a very important statute in some way, right? So for instance, there's an agreement with, the United States as to sending people back to some other country at great peril to their lives, and then the administrative decision maker interprets it in a way that's likely to have an impact on thousands of cases. That's the kind of thing where it would apply. And the underlying policy rationale is ostensibly the same as what we talked about for constitutional issues. Then you have certain jurisdictional boundaries between decision makers, which is a lot more complicated than what I said, but essentially what I said as to a real jurisdictional issue, which doesn't exist, but it still kind of does. And we'll look at that exception in a lot more detail at the end of the term. And we will pause there for now and have another capsule on jurisdiction.